Key points into Chapter 13. This is going to be very interesting for a lot of people who filed Chapter 13, or if you're considering filing 13, and this is what really where the kind of the meat on the bone is. First, you got the pre-filing credit counseling. Try to say that fast 14 times. Anyway, that counseling is the exact same as in a Chapter 7. You've got to go through the U.S. trustee program, get your certificate so that we can file the case. In a 13, the paperwork requirements may be a little less depending on your individual circumstances, but the case has to be filed. Now, when you file the Chapter 13, an added component of the 13 is your reorganization plan. In Southwest Florida, we use a form plan. Basically, it outlines how you're going to treat your creditors. Implementation of the plan is the most important thing in a Chapter 13. So you file your case. Again, we got to do that post-filing credit counseling. Now, it's the same thing as in Chapter 7. You got to go through it and get it done, get your certificates so that we can submit them to the court so the court knows that you're eligible for a discharge one day or sooner or later. Then you have to go to your meeting of creditors. Now, the meeting of creditors in Chapter 13 is a little bit different, and the reason why it's different is because you're laying out a roadmap for how you want to pay your creditors. The bankruptcy trustee's job is to make sure that you're being fair to your creditors in every way, shape, and form. And you're also being fair to the court. In other words, you're filing your case in good faith and you're complying with all the specific requirements under Chapter 13 of the U.S. Bankruptcy Code. That's really where your attorney comes in, because you have certain requirements, certain things you need to fulfill to be eligible for that relief. And you have to be willing to do what the court requires of you. So you go to your meeting of creditors, usually lasts 3 to 5 minutes, and then you're out of there. Now what happens? Well, now each month a significant event happens. You're making a payment to the court. And that payment could be to pay mortgages, could be to pay car payments, could be to pay unsecured creditors, could be to pay the IRS, taxes, for property taxes or intangible, whatever you're trying to pay back, whatever you're trying to reorganize. About 6 months after you file, or maybe even 9 months, depending on how long it takes, your case is going to come up for what's called confirmation. Confirmation is where you want the judge to put a stamp of approval on your plan. Therefore, we may need an updated budget. Most time we are going to need an updated budget so that the trustee can report to the court that you have the financial ability to make these payments. The payments are in the best interest of the creditors. You've met all the requirements of the code, and therefore, judge, both parties, meaning us, the trustee, are recommending confirmation. The court will confirm the case, and then we move forward. And then ultimately, you're just making payments. Now, what can happen after that? Well, sometimes the plan has to be amended post-confirmation. So we have to file a motion with the court to amend the confirmed plan. Or something happens where you say, hey, I don't want to keep this house anymore. I lost my job. Maybe I have to convert my case to a Chapter 7. Anything can happen in life. I've learned that over the last 15 years or 17 years helping people in bankruptcy court. So what happens is Chapter 13 has an avenue available for what happens in life. Something happens, you call your attorney, the attorney says, okay, here's what we can do, and lays out the options. Let's say we got 3 things, boom, boom, boom. We can do one of these 3 things. What would you like to do, Mr. or Mrs. Client? And then we make a plan to go forward. So in Chapter 13, I can't really disseminate all the potential things that can be happened, but the most important things are going to be the pre-filing, credit counseling, the filing of the case, the credit counseling after you file, which is called financial management, the creditors meeting, confirmation, and then ultimately the discharge. And the discharge comes when you complete your plan payments. That could be anywhere from 3 to 5 years. It could be shorter if there's a hardship, or it could be, it can't be longer than 60 months. So it could be any time in between if something happens. Again, those are the significant points of Chapter 13. An interesting part of it is really every case in Chapter 13 is an individualized plan of attack. There's no 2 13s alike, none. And although they may seem like they're the same, individual circumstances dictate every Chapter 13. So it's really important that you have a good relationship with your attorney, and they keep notes of every conversation that you have with them, so that the notes of the conversation can be recalled, so that the attorney can make the appropriate arrangements for your plan.